We will call the first case, People versus Yarbrough. This is a 20-minute grant. Welcome, counsel. You may reserve some of your time if we do not use it up, and we ask that you do your best to keep track of time on your own. And you have 2 minutes of a free fire zone if you wish.
Thank you. Mike Middlestad of the State Appellate Defender's Office, appearing on behalf of Mr. Yarbrough. I will try to reserve 3 minutes of my time for rebuttal. If you're going to have a right, you're going to need a remedy when that right is violated. Because if you don't have a remedy, you don't have a way to enforce the right. And if you don't have a way to enforce the right eventually either goes away or it gets diminished or applied in a haphazard fashion. That is the implication of adopting the opinion of People versus Bell for any and all peremptory challenge violations in the state of Michigan. Because as both sides of the debate seem to agree, you're almost never, ever going to be able to show outcome determinative harm under the traditional Luckety test. Now, the state is okay with that. They say, well, that's just the way the cookie crumbles sometimes. You shouldn't be okay with that, particularly not with regard to the right of peremptory challenges. I know peremptory challenges are not a constitutional right, but they are very important to guaranteeing, a very important tool to guaranteeing the right to a jury trial in this state. And it certainly shouldn't be all right when it puts us on a slippery slope of haphazard compliance with this court's rules. This court has an obligation to enforce its own rules, and it needs a mechanism to have ramifications and have a remedy when those rules are violated. We are asking this court at this time to accept the invitation of the Supreme Court in Rivera and join the number of states that have continued to apply the common law structural error framework to violations of the right to a peremptory challenge. It does a number of things. Number one, it gives the needed protection for the peremptory right, that peremptory challenge right that exists in this state. It also recognizes that violations of the peremptory right challenge have many of the hallmarks of structural error that we see out there. There's rights over and above the search for the truth and accurate results, and there's difficulty in establishing harm when the right is violated. It's also consistent with the plain language of MCL 769.26. MCL 769.26 gives this court some breathing room to apply a standard that is not the same as Luckety. Luckety does not have to be the one and only standard to apply when errors arise. Luckety is best suited for trial errors like the admission of evidence or the misdirection of jury. This is a different scenario. This is a structural error, even though it's not a constitutional error.
Counsel, if we were to agree with you that Bell is not binding precedent, what consideration should we give, given the fact that this has been applied one way for a really long time?
Well, it hasn't been applied for a very long time. It's only been in effect since Bell was decided, and Bell really left things uncertain. I think both sides of the Bell equation agreed that this was dicta, even the majority, the opinion to reverse.
But obviously the Court of Appeals have been applying it as if it was binding.
Well, yes, but they've been mistaken. I mean, there's been plenty of warning signs that this was not binding precedent and that this court could and would take a step back from Bell because it was never embraced. Now, it was endorsed from a constitutional standpoint in Rivera, but it was not endorsed in this state by this court, even in Kabongo, as we saw in the Kabongo decision from last term. There was a 3-3 split, and this court just could not decide or could not agree on a framework for evaluating these errors. I want to stress, though, that I disagree with the opinion to affirm in Kabongo. With all due respect to Justice Zara and the two justices who joined him on that. But there is a path forward that's narrower than this court having to say Kabongo is right in all scenarios or Kabongo is wrong in all scenarios. And that's because this fact scenario is different from the scenario that this court faced in Kabongo, in that we don't have a Batson challenge here. We don't have a ruling on a Batson challenge. Both the Kabongo court and the Supreme Court in Rivera held out the possibility that while a one-time good faith deprivation of the right to a peremptory challenge, when it's done pursuant to a Batson analysis, should not result in structural error. An arbitrary or systematic or willful violation of a state peremptory challenge rules could raise significant due process problems. And I think footnote 141 in the Kabongo decision to affirm has a nod to that. It notes that there might be a different scenario had the judge just basically thrown Batson out the window and just decided to sua sponte, dismiss a jury or deny a peremptory challenge. That's more like what happened in this case, right? We have a judge who essentially went rogue. The judge just basically decided to make up his own rules, and he did it in a way that was arguably more systemic and more structural than the single or the isolated deprivation of a right to a peremptory challenge. He basically said, I'm going to do it my way, and I'm going to tell you in the middle of a voir dire that I'm going to do it my way, and here's how we're going to do it. We contend that that was more pernicious than the single violation of a peremptory challenge because it really handcuffed counsel's ability to conduct meaningful voir dire. It really put her in a very awkward spot of deciding who to peremptory challenge. She was boxed in. She couldn't make a side-by-side comparison of the new jurors who were called to the box. And it really made it difficult for her to exercise her peremptory challenge. And she actually expressed that frustration with the court and tried to explain to him why it was harmful for her. She could not conduct a meaningful voir dire because she can only voir dire the new people in the box. So this court,
Go ahead, just a second.
If we were to amend our court rule to actually say this is how you do jury selection, the way Judge Roberson did, we could do that, couldn't we?
you certainly could. You certainly could.
And can you think of any instance in the law where a structural error could be permitted by court rule?
Well, Rivera certainly holds open the possibility that that is possible. Rivera says states can construct their own
But
rules.
that's
Yeah.
giving me an orange when I ask for an apple.
Oh, okay. The right to elocution has traditionally, now I know there's probably some uncertainty on that, but the right to elocution, while not a core constitutional right, has been seen as something that requires resentencing without some inquiry into how that would have affected the sentencer's decision. If you are not given the adequate opportunity to allocute its sentence, the courts have traditionally found that this is a structural error, including sometimes, oftentimes, under Carines. Now, I know that's a little bit in doubt, but that is something that is not a core constitutional right where this court has said.
Right. The problem I have with peremptory challenges is it's so difficult to say whether they even mattered. Like every other structural right, the right to an impartial jury, the right to cross-examine, all these things, if they're denied, you can actually see, oh my gosh, this is egregious. But when it comes to peremptories, I mean, there was some 1978, I think, law review article where they talked to jurors who were peremptorily removed and asked them how they would find the case. And they really couldn't show any error that resulted whether you would have had these people on or not. In other words, the result would have been the same. Shouldn't that weigh on us? I mean,
Well,
there's no way of telling, what the denial of this peremptory really meant to the trial.
And that really is one of the essence of a structural error. We can't figure out why. We know it's helpful, and I don't
But we
respectfully.
don't know it's helpful.
Well, I think the Supreme Court has for, 200 years, the U.S. Supreme Court has said, even though it's not a constitutional right, it is a venerable right and it is an extremely valuable tool. Now, it does serve, one of the hallmarks of a structural error is that the rule in place serves goals beyond merely the search for truth and accurate results and things like that. The jury is seen as a very important bulwark between the awesome power of the state and the individual. And it's seen as 12 citizens who stand between the government and this guy going to prison. If you give the defendant a say in deciding who sits in judgment of him, that goes a lot towards ensuring competence, both of the individual in the verdict as well as the public in the verdict. It also gives the defendant the power to remove jurors who are perceived to be biased or who might actually be biased. In other words, if the defendant has a juror who survives the high bar of a for-cause challenge, he's got 5 relatives who are victims of the crimes and 6 relatives who are police officers, but says she can be fair, that is, from a perception standpoint, that is going to undermine the confidence in the defendants and the public's confidence in the verdict if that juror sits in judgment. It gives
So
the
in your
defendant-
mind, that's like a one juror, not allowed to be struck. Is there degrees of sort of egregiousness here? Here we have, the judge had this sort of rule for how he conducted all voir dire. Is there a difference between that, which is sort of a systemic problem with the voir dire potentially, versus this one individual is denied, not allowed to be struck?
Well,
I mean, are there degrees of egregiousness on this?
I don't think under my proposed sort of alternate rule, where I distinguish the Batson scenario from our scenario, I think the motives of the judge in denying a peremptory challenge have to be taken into account, because whether I agree with it or not, there are reasons to distinguish between peremptory denials based on Batson. We want courts to police jury selection processes for discrimination. We want courts to proactively enforce the 14th Amendment. So we don't want to chill them from making a good faith ruling on Batson and say, I don't want to make a mistake, so I'm going to let this challenge juror be kicked off. But we don't have that scenario here. We don't have that when the judge just basically goes rogue. Now, these are court rules. I understand this court could modify the court rule on peremptory challenges, but these are carefully thought out. There's comment periods. There's a lot of deliberation. There's significant consideration of the common law and the value of peremptory challenges, how they best should be accomplished. We don't want judges just going rogue and applying their own rules to peremptory challenges. And I think there's good reason for that. And not only from a deterrent standpoint, but there are ways that improve the jury selection process and ways that improve the quality of the jury that this court has put into rules. And we want those to be followed, and we want those to be observed in a consistent way.
In this case, though, it's clear, defense counsel had the opportunity to peremptorily strike every person who ultimately sat on this jury, correct?
I don't necessarily, did she have a meaningful opportunity? I don't necessarily agree with that. And here's why.
Opportunity. You keep giving me an apple when I ask for an orange. Every person who sat on that jury could have been peremptorily removed by defense counsel at some point during the process.
At some point during the process, yes.
But they
Now,
couldn't go backwards.
Should that matter?
not in this scenario, and here's why. Because backstriking is important and is viewed as a very important process. Backstriking allows parties to do a side-by-side comparison of the new jurors. Backstriking allows you to observe the jury as the jurors as the voir dire proceeds. If a juror makes a face at one of the questions you ask and you already passed on that juror, you don't have an opportunity to challenge them anymore. It's lost. It also, in this case, it was sprung upon counsel right at the brink of them having to exercise the challenge. So she was faced with the very difficult, unanticipated quandary of having to do a use it or lose it move at that point. She was going to lose her right to strike this juror forever. Even if later he made a face at her, even if later he looked like he wasn't taking the proceedings seriously, if he fell asleep or anything like that. Not only that, but it interfered with her ability to voir dire, to continue voir dire. Her voir dire had to be directed only at the new jurors in the box. She couldn't go back and say, hey,
That's a pretty common practice, isn't it?
What's a pretty common practice? I'm sorry, I
The
didn't.
judge is limiting voir dire only to the new people brought up? That's how I did it. when
I
was a
think they
trial
have
judge.
discretion to do that, but I think it would be incumbent upon them and useful for them to say, hey, if this juror makes a face, I should be able to ask that juror a question.
Well, that would be an obvious challenge for cause, would it not? That juror is making faces at me, Your Honor? Well, I don't care, it doesn't matter.
Well,
Move on.
Necessarily.
But the point is, of course, that the judge doesn't have to allow voir dire at all, right? The judge can ask the questions all him or herself.
That's correct. But once you give the attorney the power to do voir dire, you can't, it puts her in
But
a,
your argument seems to be that once you allow the lawyers to ask questions, and this is even aside from peremptory challenges, then you have to allow them to ask whatever questions of whatever people whenever they want. And that's just not how, in my experience, it's done probably in any courtroom in Michigan right now.
my argument isn't that that's an independent violation. My argument is this is how it messed up the attorney's ability to make a sound decision on jury selection. Like I said, it was sprung on her at the very beginning. It's one of the pernicious
But
effects.
isn't the idea, like you said, yeah, as a lawyer, would you like to be able to have all these opportunities to do things and sort of make whatever judgments are made on who would be good or bad on the jury at all times? Yeah, that would be optimal if you're the lawyer.
Yeah.
But when you're the judge running the process, the idea is to make it a little more efficient. And so I would let the lawyers ask the questions, as long as they were not inappropriate questions. of the jurors and not go back. I mean, I see Judge Roberson went one step further, which I did not do, frankly, when I was a trial judge, and limit the peremptories. But isn't it the same idea? You had a chance to zero in on each of these individuals and make your assessment of them. And having done that, you can say, yeah, there's something about this person that I just can't live with or don't have a good feeling about. And the judge is basically saying, I'm not gonna let you gauge, I like this person a little more than that person, or this, for whatever reason. I'm not gonna let you make those kind of calibrated decisions when it comes to peremptory challenges. What's wrong with that?
That is the essence of a peremptory challenge. It is the essence of a peremptory challenge to let the party, a litigant, decide, have a role in the best jury that fits his needs at that moment. It gives confidence in the jury verdict. It improves the quality of the jury verdict because it allows us to challenge jurors who are, disinterested, sleepy, bored,
Well,
not really invested.
you keep bringing up things that would be a reason for a challenge for cause. They're disinterested, not paying attention, falling asleep. Those would be reasons to challenge somebody for cause, right?
Not necessarily. The challenge for cause is pretty high bar. In fact, judges do a very good job. We all know that judges rehabilitate jurors. If they make statements that raise a concern about the jurors' partiality, they do a really nice job, especially when they have
Because obviously, as a trial judge, if you don't do that, and this huge jury panel gets a whiff of the idea that all they have to do is make any type of objection or signal of discomfort, and then you end up having to replace 50 people. Then you have to do jury selection the next day with the next panel, because as a judge, you've decided that anybody who says anything is gonna be allowed to be excused for cause. So, there is a process, the integrity of a process that has to be maintained, right?
And that integrity was not maintained here because this attorney went into this voir dire and this jury selection with 2.511, prepared to follow 2.511. And the judge changed the rules midstream.
There's no question about that, except that the judge made it very clear at the onset that the judge wasn't gonna follow that court rule. I'm not, saying that that's what judges should do. The judge should follow the court rule. Clearly, we should follow the law. But from a fairness perspective, at least the lawyer knew at the beginning of the process, these are the rules I'm applying. They're gonna be different.
And we can debate whether 2.511 is a sound way to do voir dire and jury selection, but again, it is a court rule that much thought has been put into it, reflects years of common law.
But it goes beyond that, right? Because look, I was happy to follow that rule. I'm a rule follower. I read the rule. That was good enough for me. But the idea is, if you don't follow the rule, is it a structural error? Now you're on to something much, much larger than Judge Roberson had a little different opinion about how peremptory should be exercised than was the court rule, expressed in the court rule.
And again, those rules, it's important that we follow those rules and it's important that we enforce those rules. And again, there's lots of debate that goes into those rules. There's comment.
But not a violation, you're not here telling us a violation of every court rule is a structural error, are you?
No, I'm saying that the peremptory challenge right is far more significant. And I'm saying that there's reasons to distinguish between the Batson problem and what occurred here. Batson is, there's a balancing interest. There's a 14th Amendment concern.
Okay.
We don't have that here.
Did defense counsel ask for too much when he or she preserved the error? They made the record, and the judge said, "What are you asking for?" And at this time, Your Honor, I think the remedy would be a new veneer based on the fact that we would have made some challenges. Isn't that too much? Wouldn't a more controlled or precise remedy would have been, well, Your Honor, I noticed juror number 3 appeared a little bit uncomfortable with some of the questions that were asked of the newest juror. I'd either like to peremptorily remove that juror or have an opportunity to voir dire as to what I believe I observed. Wouldn't that have been the proper way to go about this? And at this point, hasn't defense counsel asked for too much? And then in conjunction with that question, because I know you're running out of time, should we require some sort of offer of proof in these situations?
Not when it's a structural sort of error like
Well,
this.
we have to decide if it's structural.
Yeah.
And so structural is a pretty strong remedy, especially for something that could be changed with a court rule. If we were to make a rule when these types of violations occur and you have to show harm, shouldn't we require an offer of proof? I know you don't like that remedy, but as we're trying to work this way through, what's wrong with that?
Right. Under the circumstances of this case, counsel made it very clear that she didn't want to do certain things in front of the jury. And she had already said, we have a jury, Your Honor, but subject to what she had already put, the objection she had already put on the record there. And it was pretty clear from the interchange between this judge, he didn't allow her, the leash, to do much of anything, including make an offer of proof. In fact, he cut her off and said, take it up for the Court of Appeals when she tried to explain herself further. She explained the authority and she tried to explain it, and he said, you know what, take it up with the Court of Appeals, we're done here. And so I don't think she really had the opportunity to make an offer of proof. Judges should allow.
But would that be the right process to remedy this? I mean, I think Justice Zara asked a valid question. Is that one way this could have been remedied? Assuming the judge would have allowed her to move forward and be more specific in her objections.
I can see a scenario where the judge could change the rules and allow for backstriking, and that's what has occurred in the past. There's been violations of the peremptory challenge rules where midstream the judge says, you know what, I made a mistake and I'm going to allow you to start backstriking it. And this court, or at least the Court of Appeals, has ruled that that was okay, that cured the error. So yes, if there's a request and an opportunity to make that request, I can see a scenario where that would be allowed, because then you're right, 2.511 has been followed and your full array of peremptory challenge right has been observed. But that's not what occurred in this case.
Should counsel have to be specific on who they would have, assuming that we thought some sort of proof had to be presented? Would counsel have to present, this is who I would have struck and I was unable to strike them?
I think ideally that would be, but under the circumstances of this case, where the entire, voir dire structure was altered, the entire jury selection structure was altered by the judge's rule, I don't think it's incumbent upon her. Again, it affects, I understand that judges have significant control over how voir dire is conducted, but when you go into the court planning to do voir dire a certain way, and that's been taken away from you right in the heat of the battle, it makes it far more difficult for you to comply with the need to make an offer.
Doesn't that happen all the time in trial? You sound like an appellate lawyer if you think that there's no unexpected things that happen during the course of a trial.
Of course they do, but jury selection and observance, parties and attorneys need to rely on judges following the rules. And it's one thing to say objection, hearsay, granted, or one thing to say, I'm going to instruct on this and not the other. It's another thing to say we're going to change the rules at a sidebar after I've conducted voir dire.
Did defense counsel ever specifically point out the rule to the judge?
Yes, yes. She pointed out the rule and she cited cases that said this is not the way you're supposed to do it.
Thank you.
Thank you.
May it please the court, Deborah Blair on behalf of the people, the Wayne County Prosecutor's Office, the appellee in this matter. The court has asked the parties to address two issues. First, whether the harmless error standard of review applies to technical violations of MCR 2.511G, and two, who bears the burden of proof that the error was harmless. In regards to issue one, there is no reason to elevate the alleged denial of a peremptory challenge to a structural error, especially where the right to a peremptory challenge is not enshrined in the Constitution. Also, there is no reason to reverse the defendant's conviction where, by all accounts, he had a fair trial and was convicted by overwhelming evidence. This was not a closed case. The defendant was convicted based on direct evidence, DNA evidence, physical evidence, and cell phone record evidence. The victim suffered a brutal kidnapping, rape, and beating, and yet the defendant now seeks the court to reverse an otherwise proper conviction based on the trial judge's technical violation of a court rule. Why should the victim have to suffer through another jury trial where there was no outcome determinative prejudice committed? The defendant was convicted by an impartial jury of his peers based on overwhelming evidence of his guilt. To award the defendant yet another trial in this circumstance is not only an affront to the harmless error jurisprudence, but also an affront to common sense and substantial justice. The voir dire in this case was thorough enough to reveal any biases against the defendant. Each juror was thoroughly questioned as to their background, and they were thoroughly instructed on the concepts of presumption of innocence and burden of proof. There is no argument that this jury was anything other than fair and impartial. In regards to issue two, the defendant bears the burden of proof that the error was not harmless under MCL 769.26. Here, because of the overwhelming strength of the evidence, there can be no doubt that the error in jury selection was harmless. Under the standard for non-constitutional preserved error, the defendant has the burden of establishing a miscarriage of justice under a more probable than not standard. People versus Lucity, 460, Mich. 484, 1999.
How do you establish that with an error relating to peremptory challenges?
Well, it may be possible that the defendant cannot establish that, especially in this case, where there's no allegation that any particular juror was not appropriate to sit on the jury, or even the defendant has not identified any juror that he didn't want on the jury.
But they weren't allowed to, correct? I mean, the way the record was, they weren't really given that opportunity, were they?
Oh, they were given a full opportunity to question each witness.
No, I mean, they weren't given the opportunity to say who they would have struck instead, because the judge obviously said, we're going to follow this rule, take it up with the Court of Appeals.
Well, they could certainly have asked to expand the record in the Court of Appeals. They did not do so. They haven't identified it in any of their briefs. They haven't asked for a remand. You know,
But can
another.
you think of any example where a defendant could prove harm? I mean, I realize you're saying it doesn't exist here. I understand that. But can you think of any example where they ever could prove harm?
I can't think off the top of my head, no, but, you know, if this was a closer case, maybe, you know, and, you know, even in a Cabango, the case of Cabango where you had the attorney specifically identify juror number 5. I don't want her sitting on this jury, and yet she got to sit and decide this case. I mean, in that circumstance, that is more akin to identifying a prejudice. not
Right, and that
like
was a
this
Batson case, so I recognize, and this is a little different. With peremptories, obviously, you can strike them for any reason you want. So, and maybe it doesn't rise to the level of cause. So it's just, obviously, the defendant's arguing it's impossible to prove prejudice. That's why we have to have this extreme remedy. And I'm just wondering, is it ever possible, under the harmless error standard, to get to, can a defendant ever overcome that, ever?
Possibly not, but not every error leads to reversible error. Not every error in a jury trial leads to the defendant getting a new trial. That's just simply the nature of criminal law.
If the court is uncomfortable with that, where do we go? And I'm wondering whether defense counsel perhaps dropped the ball when the court specifically asked, what are you asking for? And counsel didn't say the opportunity to backstrike or voir dire, or to identify jurors who subsequent in the proceedings I have concerns about, even if it's in a sidebar or after the jurors have been dismissed. Here is why I want to dismiss juror number 14, and then make a record of this. But to simply say, my remedy is to start over, is that just too much, given the fact that this is a peremptory and not something that's traditionally been identified as a structural error?
It's absolutely too much. It's completely amorphous and speculative. And with this level of evidence that the prosecution brought in this case, I am firmly convinced that any juror who applied their oath would have found this defendant guilty. I mean, we could have jury selection for 2 days. The jury would have come back guilty. That was the strength of our evidence.
In making a rule now, when there's a violation of the rules relating to peremptory challenge, identifying the case, how do we articulate it? If the court's uncomfortable simply saying, well, there's some errors you just can't prove, and if you have the burden, you're stuck. If we're not comfortable with that, how do we proceed?
Well, we could proceed as you said, that there has to be some record evidence more than some amorphous idea or speculation that the defendant was actually harmed by what happened in the trial. And you can't show that in this case. I mean, nobody was really objectionable.
But you're saying that probably there's no defendant who can show it in any case, right?
I can't think of all the possible scenarios, but, I mean, it's possible, but as I said, not every error leads to a reversal.
So assuming for just for sake of argument, that maybe saying I get a whole new veneer, you know, was a mistake or a wrong judgment by counsel, and should have asked, let me start backstriking, let me identify who it is. Was there something like that should have put counsel on notice that that's what she should have done? I mean, were there existing cases that say, hey, wait a minute, midstream, if you can stop it and you can do something short of a new veneer? I mean, so should she have asked for something less than that?
Well, I mean, perhaps it would have been better had she done that, but there's not a lot of cases out there because we don't use this method anymore, and judges shouldn't be using it. I don't know why Judge Roberson thought it was a good idea.
So what's the
but-
impetus if we're not gonna, if there's no way to really prove error and it's never going, there's gonna be no consequence to a judge who does this, and we've decided for good or for ill that this is the way we think our rule should be, why do we have it?
I don't believe there's a consequence here because Judge Roberson, God rest his soul, is dead. But certainly in the future, you can enforce with future judges, hey, look, don't do this. This is not correct. This is
What
not
about
how
any
you
other
do
error?
what-
Maybe
voir
not
dire.
this particular error, but like what's the teeth if, like, what's the point of having a rule that we recognize as important to have, maybe not of constitutional importance, if there's no way to enforce it?
Well,
Because-
the teeth shouldn't be that the victim has to always suffer through another trial. I don't believe that's the proper remedy.
Right, but is that
Maybe the teeth is you go after that judge and say, look, you know, you've got to fly right. You got to go by the rules. I mean, there's follow-up with the Judicial Tenure Commission. I mean, not everything has to result in the victim suffering through another jury trial for a technical violation of the rule. Other than that, therefore, for all above reasons, we ask that you affirm the Court of Appeals. Thank you.
The case will be submitted.